would like to introduce our speaker, fresh in from New York. Bruce Gibney is an American writer and venture capitalist, and once upon a time he was a litigator, so he has a little background on what he's writing about here. He has worked at a hedge fund and as a partner at Founders Fund, which is one of Silicon Valley's leading venture firms. Some of his investments include early stakes in PayPal, Lyft, SpaceX, Airbnb, and many others. And in his best-selling book, A Generation of Sociopaths, How the Baby Boomers Betrayed America, he examined American stagnation under baby boomer politics. And now in his latest book, The Nonsense Factory, which is available for sale tonight from Barnes & Noble over here at the table, as well as he'll be doing some book signings after the program. He argues that the entire legal factory, from law schools to judges, bureaucracies, police, and the presidency, it's all fallen apart. So anyway, please join me in welcoming Bruce Gibney to the stage tonight.
Thanks so much. Well, thank you guys for having me. I appreciate it. Sorry if I have a little nerves. I am from San Francisco, New York. I don't see a ton of cell phones, and no one is overtly hostile, so that does not put me at ease.
A little closer to your mouth, please.
Okay, all right, well, there we go. That's a bit more New Yorkish. Now I feel better. Thank you. Okay, so first, thank you for having me. And I'd like to start tonight. I should just point out as a disclaimer, all hate mail goes to my publicist. That's where the death threats go. Let me start with a quote from Louis Brandeis. And in 1912, Brandeis said that if we desire respect for the law, we must first make the law respectable. So note the ordering of that quote. Brandeis doesn't say that we should respect the law just because it's the law. He says that law has to earn our respect first. And he all but implies the law, circa 1912, was not respectable. Now, there are a few good reasons to pay attention to Louis Brandeis. First, he was from Louisville. Second, he was a genuinely brilliant lawyer, and he became one of America's finest Supreme Court justices. And third, he was absolutely right. And I'm sorry to report that he is still right over a century later. The law is not entirely respectable. It is not respectable that the police can seize your property without charging you with a crime first, or indeed without ever charging you with a crime. That process is called civil forfeiture, and it can happen to you at any time. It is not respectable that the right to a jury trial has all but disappeared. It is not respectable that our courts conduct fewer trials today than they did in the 1960s, not per capita, but in absolute number. Fewer trials, period. It is not respectable that there is no educational requirement to be a federal judge, or that 22 states allow non-lawyers to become judges, and in 8 of those states, those non-lawyer judges can hand out jail time. It is not respectable that the legal system requires us to obey the laws, all of them, while exempting itself from the rules via doctrines of sovereign immunity, a practice the law has used to excuse concentration camps, unconsented medical experimentation, theft of private property, police brutalities, and other basic violations of our rights. Nor is it respectable that there are 4,400 federal criminal laws and another 300,000 federal regulations with quasi-criminal implications, plus some unknowable number of state and local equivalents. It is not respectable because that means that our legal system, a system designed and operated, to be clear, by our employees, has essentially branded we, the people, as criminals. That is offensive to our dignity as self-governing, decent citizens. Worse, there are so many laws, in fact, so many laws that the Department of Justice once tried to count them and failed. There are so many laws, and they are so complicated and counterintuitive, who has paid taxes, who has done a remodel, right, that the state has almost total discretion over whether it turns one of us, a proto-criminal, into an actual convict. Yes, you can fight back, but the median American can only afford about 4 days of legal representation. It's not exactly an even match. It's even less in New York, where a partner now bills $2,000 an hour, right? So that's It's getting up there. So now we can disagree about what exactly constitutes fairness or American values as part of our general dialogue as citizens. But I think we can all agree that when our public servants have wide discretion to take away our property and our freedom, when the highest court in the land has said we don't even have an absolute First Amendment right to discuss the Constitution in public, when all that happens and the legal system has the audacity, as John Roberts recently described it, to declare itself as a model to the world, then something has gone terribly wrong, at a minimum. So, I'm not a fan of the law. American law has some deep problems, and I do have a full and complete indictment. But tonight I'd like to offer a sort of general explanation where I think those problems might have come from and what will happen if we don't fix them. And like my first book, the spoiler is, of course, we are all going to die. The only question is how slowly and how painfully. And I would prefer for some more optimistic conclusions, but we'll see. But first, it's important to explain just what the law is and what the law is for. And these, oddly, are subjects that are not taught in American law schools. They are taught in other law schools, in other jurisdictions, in a class called jurisprudence. But in American law schools, no one teaches you what the law is or what it's for, which is something like medical school, teaching you how to cut into a patient without telling you that the purpose of doing so is to heal them. This is a strange curricular gap. And I think it explains a lot about why American law is so frustrating. And while I've been to law school, and I have taught by accident 2 law school classes, and I have employed legions of law school graduates, I also only have 30 minutes, and my hosts have limited me to only 3 obscenities, so I will simply leave it at American law schools are not terrific, by and large. But returning to the foundational questions, what is law and what is it good for? Law is a system of... I mean, who actually has a great definition of what law is? This is not a trick question like, why do we tolerate lawyers? Why do we tolerate Congress? Okay, don't worry, you can go to law school. No one will tell you the answer either, because professionals don't agree. But I'd like to propose a definition. So law is a system of rules that allows society to coordinate its behaviors. It is society's operating system. It's what makes us stop at red lights and prevents every intersection from becoming a bloodbath. That's not a bad thing. But for law to do those jobs, at least 3 things have to be true. First, our laws must be clear and understandable by the people to whom they apply. Second, they must be applied evenly. That is to say that no one is above the law and no one is beneath its protections. And third, I didn't say that these actually happened. I just said that they should happen. Don't worry, I'm heading to your same emotional position. Third, the legal system as a whole must be recognized by most citizens as legitimate. And on all these metrics, I believe that American law is failing. So let's start with clarity. American law is not clear. As we've already seen, there are so many laws that even if each individual law were a model of clarity, the aggregate would be an incomprehensible gumbo. And to say that individual laws and regulations fall short of being perfectly clear is to risk radical understatement. The state of California, by the way, is still trying to figure out the taxable treatment of a calzone because it is not clear if the tomato is biologically a fruit or culturally a vegetable. But it has figured out that popcorn, for the purposes of the heated food sales tax, that movie theaters heat popcorn to dehumidify it, and not for the purposes of keeping it warm. And so this literally is actually what keeps our government occupied. So this is where your tax dollars are going. I'm not going to get into the case where the San Francisco Zoo had to argue that it was only feeding its animals because they might be eaten by humans later. Yeah, so the American law is not clear, and one reason for that is that Congress is badly understaffed. Now, I can understand sort of the emotional, contention that the sort of optimal number of Congress people is 0. But insofar as it is non-zero, we should probably have more than we do. There are only 535 members of Congress. Only a third of them are lawyers. And most of them have no idea how to draft a law. And while I am not personally a fan of government bloat, what's really alarming is that a lot of the legislative activity is outsourced to legislative staffers who have primary responsibility for drafting our laws. There are only 600 in Congress, only 600 people to write the operating system that governs 325 million people and a $20 trillion economy. And I can tell you from personal experience that there are more people working in Silicon Valley to figure out the best way to sell you cat food than there are writing our tax code. And the results are entirely predictable. American programmers are very good at selling you cat food online, but American legislators are not very good at making law. The result is that most of our laws tend to be vague and incomplete. And so, as a result, what actually becomes the law is decided by other people. And this creates a few problems. First, it creates separation of powers problems. And we're going to discuss the federal bureaucracy in a second, because what Congress actually does when it writes the laws, it provides a set of general instructions. And it says, we would like you to tax people enough. And then it says to the IRS, figure the rest out. The problem is that the Constitution vests all, quote, all legislative powers in Congress. And so it is not entirely clear that it's constitutionally permissible for Congress to devolve its powers onto the federal bureaucracy, which, if you look at the budget and the head count, constitutes 99.7% of the federal government. Now, the more sort of that is an abstract problem, and sort of, legal scholars can debate it all day long. At the end of the day, we're going to have a bureaucracy because that's just the way it is. Also, I don't particularly want to see 2.1 million people in Congress. 535 might not be enough, but 2.1 million legislators is probably too much. That's the number of people who work at the bureaucracy. The more sort of crucial problem, however, is that the bureaucracy doesn't report to Congress. It reports to the executive branch, which means that unlike our high school civics lessons, where we have the classic three branches of government, right? So the legislature, the executive, and the judiciary, the legislature has outsourced its lawmaking responsibility to the executive branch. And to say that the Congress and the White House don't always agree is, again, to risk another radical understatement. Now, the difficulty is that these regulations become the functional law by which our day-to-day lives are governed. Now, most tax lawyers, for example, do not read the federal tax code. They read the IRS regulations, right? So when you go to remodel your home, your contractor doesn't really look at the building code per se. It tends to look at the sort of regulations. We all, in our daily lives, we all are probably in some version of a regulated industry. You don't take out the United States Code to look at the law that Congress has written. And by the way, here's an interesting side point. The law is so badly written. The U.S. Code is actually Cliff Notes. It's not the law because it hasn't been passed by Congress and presented to the president for signature. It's a cheat sheet, but even judges use it because the law is that bad. But nevertheless, returning to the point at hand, the law is so bad that we don't even actually, the Supreme Court doesn't even cite the real law. They cite the Cliff Notes. This is like getting tenure at the local university studying Shakespeare by reading Wikipedia, but okay. The problem, of course, is that these executive bureaucracies not only are charged with enforcing the law, they actually write the regulations that they enforce, which means that the people who get to haul you off to jail functionally get to say what crime it is that you committed. Now, you might say, well, at least we still have the judiciary. But no, the bureaucracies actually contain within them a court system. And this applies from everything from the immigration courts, which operate inside the Department of Justice. I assure you this will be a bipartisan critique. I hate all of the law equally. Where the Attorney General sits as essentially the Supreme Court and sets precedent. It applies in immigration courts. It applies in SEC courts for insider trading, where the SEC, just by coincidence, has a 30% higher chance of winning its cases, interpreting laws that it wrote, prosecuting you with its own staff, using judges that it employs. And it applies in Social Security courts as well. So if you have an administrative appeal of a Social Security determination, you can take it up with Social Security using their own rules in their own courts. In other words, we do not have a three-branch government. We have a one-branch government. And I think that this is actually driving a lot of discomfort with the law on both the left and the right. And so, the sort of stereotypical sort of more left-leaning critique of police brutality and discriminatory enforcement, and the sort of traditional sort of rightist critique of the regulatory state run amok, and sort of passing arbitrary regulations and interfering with business. These actually are, in their purest form, the same critique. They are a critique of arbitrary power. They are a critique of a legal system that has allowed, through sheer complexity and size, all powers to be collapsed into a single branch of government, because Congress can't do its job. Now, again, sort of the judiciary does stand out, and we perhaps repose a bit too much faith in the judiciary. It does stand out as the branch that has been the most insulated, at least the federal side. And I would like to, because I am required to, make one compliment to the legal system. The federal judiciary as a whole is actually quite good. I don't know if it will remain so, and this is, again, not a comment on any recent appointments or any appointments made in the past 20 years. But, sort of federal judges are paid about $200,000 a year. If you are a 55-year-old, highly intelligent professional lawyer working in Manhattan for less than $2 million a year is a waste of your time. This is a gap that the prestige of government is not going to be able to bridge forever. But nevertheless, the federal judiciary is pretty good, except at one thing. It doesn't actually understand how the rest of government works. And this is a problem because when it comes time to fight back against the executive branch, when it comes time to interpret vague regulations, the judiciary has no intuitive sense for what it is Congress intended or how the executive branch might manipulate its rulings. And this is one of the sort of core problems with our legal system. In theory, it can only work when all parts of the system are pulling together. The public, the legislatures, the judges who interpret legislation, the regulators who implement legislation, the police officers on the beat who have to apply the laws, and you, the citizens, who have to obey them. The problem is that the different parts of the system don't necessarily understand each other. And rather than point out, a whole series of these sort of mistakes, I'm going to pick on the judiciary because I think in most people's imaginations, or most people's conceptions, and in reality, the judiciary, the federal judiciary, is by far the strongest. So I am not going to pick on the weakest. I'm going to pick on the strongest. So judges are asked to and this will be an example of how the system fails to understand each other. And by the way, again, this is the best part of the system. Judges are constantly asked to interpret ambiguous statutes, and to do so, they use elaborate canons to figure out what Congress meant when it was writing those statutes. And you've probably heard about this or read about this in the newspapers when people say, well, he's a textualist, or he's an originalist, or this person relies on legislative history. Everyone's just trying to figure out what ambiguous words mean. It turns out that no one actually knew if any of these canons reflected reality, and then two scholars, one at Yale and one at Stanford, decided that they would find out. And the empirical analysis showed that most legislators are either unaware or actively disregard judicial canons of interpretation. So all the speechifying by the Scalias and the Breyers and the whoever's of the world turns out just to be so much hot air. The whole judicial mind-reading trick is a farce, and not just because legislative mind-reading presupposes a legislative mind to read. It can even be more absurd because sometimes they attempt to read our minds, we the citizens. They try to figure out how ordinary citizens, and this is especially the case for criminal statutes, would interpret an ambiguous statute. So let me take one example from People versus Moreo. To a normal person, what does it mean to, quote, carry a firearm? This usually involves one trip to dictionary.com for the ordinary person, I think. Certainly it does for me. But no, or listen, this is a library. We can be fancy. Oxford English Dictionary. It's fine. No. Justice Breyer thinks that we need to not only turn two dictionaries. We need to study Latin etymology, read Robinson Crusoe, Moby Dick, the King James Bible, relevant Supreme Court opinions, and conduct a database search of the Wall Street Journal and the New York Times. I'm sorry to profane a library, but reading Moby Dick to figure out what packing heat means is like watching Game of Thrones for tips on management technique and wedding etiquette. So these sorts of breakdowns affect all parts of the legal system. But again, one of the sort of most disturbing things is they might not matter, because to the extent that 99.7% of government is the executive, and Congress has outsourced its responsibilities to the executive branch to write laws, the executive has an inherent ability to enforce laws, and the judiciary is either off reading Moby Dick or allowing itself to be subverted by these in-house kangaroo courts run by the agencies, from Social Security to immigration courts to whatever, EPA, so on down the line. That means the executive gets to decide everything, and that means the law begins to feel arbitrary. Because there are any number of laws to pick from, and because no one can figure out what they mean. And because the executive constitutes 99.7% of government, that means the executive decides. And this isn't a critique of Donald Trump directly. This has been the case since FDR, and really accelerating since Truman. Every single president has chosen at their option to simply ignore what Congress has done and to issue their own regulations, whether or not compatible with congressional design or public opinion. One of the ways that they do this is through executive orders. Another way that they do this is through something called a signing statement. The signing statement is one of the most lawless creations in American legal history, and it really sort of takes on life with the Truman administration. And what a signing statement is once Congress passes the law, the Constitution requires the president to either sign it or veto it, right? We all remember this. The signing statement is the worst of all worlds, and what the signing statement does is the president signs the law and then issues a statement immediately denying that the parts of the law that he doesn't like have any force. Every president since Truman has issued dozens of signing statements. Trump has actually not issued that many, but that's only because Congress has done almost nothing since he's been president. And Obama was relatively circumspect about this, but George W. Bush, over 100. Clinton was also a frequent user of signing statements. There is something a little odd, right? That the man who is our most senior law enforcement officer, who is entrusted by the Constitution with seeing, and this is a quote from the Constitution, that the laws are faithfully executed, will sign a law and then deny its legal force. So of course we all sense at some deep level that something is wrong, that the law has become arbitrary, that it has become capricious, that it has become political and an instrument for self-service, because at the end of the day, it has become the instrument of an autocrat. And it is unfortunate that the other parts of the legal system, off doing their own things, understaffed, overwhelmed with reading Robinson Crusoe or the Aeneid in the original Latin, have not pushed back. But that is where we are. And that is why I think people on both the right and the left are unhappy. And that is why I think that we will be unhappy in January 2021. Because I would ask you to cast your mind over the field of candidates for 2021. It doesn't matter what Congress does. Let's put them to a side. And it certainly doesn't matter what the judiciary does for now, although I think that's going to change. Every single candidate speaks in the language of the first person singular. I will do this. I will do that. And there is no break in precedent from the past 80 years because every president has operated this way. I will do this, I will do that. It is the decree of the autocrat, and no one has pushed back. When Elizabeth Warren says that she will operate over congressional objection and Republican obstructionism, her terms, to enact her various policies, and for a law professor, she has offered a lot of unconstitutional policies, same is true of Trump, that she will override Congress by executive order. She is taking from the same playbook as all presidents, including Trump, that have preceded her, if she is in fact the nominee. And almost every other candidate has proposed something similar. And even Mayor Pete has said that he will simply reconfigure the Supreme Court, if it so pleases him. Now, I think that was just an ill-advised campaign, stump speech, but nevertheless, that is an astounding thing for a serious presidential candidate to say. Well, if I don't get what I want, I will simply recompose another branch of government. Now, the good news for him, if he is elected, is these branches of government have already decomposed. So there is no need to recompose them. But that is the future that we face. It is also not irrelevant that for the past 40 years, we have operated in the United States in a permanent state of emergency, right? State of emergency, threat to public safety. These phrases, from Robespierre to Stalin to today, have always been used to subvert the law. They are never used to advance the rule of law, but only to subvert it. And the United States has been in a state of emergency, continuous state of emergency, since 1979. In fact, it has actually only experienced 4 years where it was not in a state of emergency in the mid-1970s as a result of the aftermath of Watergate. And the reason for that is that presidents have said that there are times when it is no longer convenient for us to follow all the niceties of the law. And this is not some trivial thing like Congress exempting itself from jury duty, which, by the way, it does. I'm not kidding when I say that they just really think that they're above the law. This is a serious thing, and every single president, Truman with the steel seizures, and so on down the line, every single president has adopted the posture of a state of emergency. In fact, the state of emergency that has been ongoing the longest, the one declared in 1979 over the Iranian hostage situation, has been going through 5 different Batmans, 2 of whom have lived so long they made a caper flick about the Iranian emergency, the hostage-taking that spawned the 1979 emergency in the first place. Okay, if an emergency has gone on this long, it's no longer an emergency. But that is the direction that we have taken. We have taken a course towards a system of one-person rule. And whether or not you like that one person, you should not like the configuration of events that have brought us here, because you never know who the next person will be. And so where does that leave us in our present moment? And I think this, again, I'm not known for my uplifting books, I'm sorry. This leaves us in a very dangerous place. We have seen this happen before, not only in the United States, but in other countries. What happens is that the people start to lose faith in the law and the legitimacy of the law as an even-handed and fair and predictable and clear and principled means of controlling society. They see it as a mechanism for abuse and self-enrichment, and sometimes they just stop listening. Sometimes they just stop paying taxes. Sometimes the people at the top simply dispense with the pretext altogether, and they declare what's known as a state of exception. And the state of exception says they are going to overturn the constitutional order. There's an interesting question about whether or not we're in a state of exception now or we will be in 2021. Doesn't matter who wins. Probably will be in the same place either way. And the argument is always that the legal system has seized up to the point where we need something entirely new. And now, I have critiqued the legal system all the way through this conversation, but I would never propose something so radical as simply setting aside the constitutional order. But again, I would encourage you, look at the candidates for 2021. Every single one of them is proposing something that is deeply antithetical to the constitutional backbone of this country, and that has been the case for many, many presidents. What is the alternative to the state of exception, to the overturning of the constitutional order, whether it's in 2021 or 2028 or whenever it is? And the answer is a more subtle constitutional update. So if the law and society's operating system, at some point, we just have to, with our iPhones, however irritating it may be, click on, go ahead, at 12 p.m., do it. Update. I will enter my login instructions all over again. It will be inconvenient, but the phone will be more secure and the battery life will be better. We have to be willing to tolerate this. And some people say, no, there is no way for this to do it, for America to do this. There is no way for us to update our Constitution. The framework is too rigid and our politics are too divided. And I say that that's not correct based on our history. And our history has shown that we've been through at least 5 different constitutions, only one of which required a massive political upheaval. Well, 2 if you count the revolution. Probably ought to. The Articles of Confederation, the original Constitution, the Bill of Rights, which radically reconfigured the Constitution, the Reconstruction Amendments, the direct election of senators and the enfranchisement of women, the integration of the 14th and 15th and certain parts of the Bill of Rights against the states, and the New Deal. And at each and every turn, we did just enough to keep the constitutional machine humming, but it didn't require a total and complete break with what made us an American society subject to the rule of law, and we need to do that again. The choice can't be between inaction and total constitutional rupture, but on the present course, and again, I go through this at length. This system is not working. It is not serving its basic purposes for you and me as citizens. But that does not mean that we have to set the entire thing aside. What it does mean is that there's only so much longer that any of us can take this. And it's not a right or left issue. It is a fundamental issue with the illegitimacy of a system that no longer takes its obligations to us, the people, seriously. So thank you for your time.
I don't really have a question. I just want to confirm about respectability. It happened to me. Our house was broken into. I felt like I was a victim. It was not respected. The criminal, he got plea deal, whatever the hell that is. And I had to badger the detectives to get my things back. They didn't care. They never called me, never nothing. I went all the way to the chief of police, and then his lackey calls me and says, "Hi, how are you?" And I said, "I want to talk to you." And I'm very pleased that you are doing this because it's the police, it's our judicial system locally. It's just horrendous. And I asked the detectives, I said, "Why can't you put out a little paper and give it to the victim, whatever happens?" And this is generally what happens. The detective does this, the county attorney does this, this is the timeline of what you can expect. Going down to court, and then the victim wasn't there, had to pay $10 for parking and waste my time. Anyway, you get the drift.
Sure, you wanted to be treated as a citizen who was protected by the police and in a decent and responsive fashion. There's nothing wrong with that. The only thing that's wrong with that is that it doesn't happen very frequently. And by the way, the police, who have been asked to do a lot that really shouldn't be their job, they're not mental health workers, but that's what they've been asked to be. They don't solve any crimes, really. Almost no crimes where the victim doesn't identify the perpetrator do the police solve.
We have one over here.
Sorry, we'll just ping pong.
All right. Thank you for the talk. I have two questions. The first one is what you described really at the federal level, or is also the case at the local and state level? The second question is, are you the only person who's sounding alarm, or are there some other legal scholars who have the similar view? And who will be the driving force that can reshape what's currently happening? Is that legal scholars, or has to be some politicians joining force?
Right. So the first question, so I have focused on federal law because it affects everyone regardless of state. But yes, the same thing has happened at the state and the local level. Very small municipalities or very small states like Wyoming, it's more responsive. Actually, Wyoming is what the founders sort of thought was the optimal size for a city-state. But the second question as to sort of who will drive reform, unfortunately, I do not think it will come. So I think we've more or less given up on the conventional political establishment. In fact, actually, our present presidential moment is a reflection of that, and our next presidential moment will probably be a reflection of that. You would hope that it would come from legal academics. Brandeis pioneered our right to privacy. Now, it took 20 years for anyone to buy into it. But a lot of our modern freedoms depend on what that man wrote in a law review article. I don't think we're going to be able to say the same thing about a lot of what's being published today. Sort of one of the problems also with critiquing the legal system, and this is a problem with Congress, a problem with a lot of industries, is that many people in the legal elite, and I live in Tribeca in San Francisco. I don't have a problem with elites, but so I'm not using it in its most pejorative connotation. But sort of like in this rarefied sort of, the fancy, sort of influential world, they all need favors from one another. So if you're an up-and-coming academic, you're not going to critique law schools, right? The bottom half of which probably shouldn't exist. If you're a tenured scholar, you probably are not going to critique Congress because sometimes you need access to them for your publications, or you need grant money from them. It is, sort of if you're a judge, there's really almost nothing you can say. If you're a congressman, you're going to say everything's great except for the other side. So unfortunately, sort of, although academia should be one of the places where we should expect reform to be coming from, I have seen almost no real indications that sweeping legal reform will come from within academia. And again, sort of, there are one or two notable exceptions, right? Barack Obama was a law professor, and he probably did do something to change the system. And Elizabeth Warren, same thing. Not sure I agree with everything that these people propose, but the only way to do it is actually to leave the academy together. But the problem is once you leave the academy, you also leave objectivity behind as well.
Well, we started with the Articles of Confederation. That was our first shot at this. And then we had the Constitution after that, and we changed some things because the articles weren't working. What do you see are the main areas where we need to change the Constitution or make accommodations?
Right. So I think that we need to accommodate the sort of radical population disparity between the states a little bit. I think that we need to come to some conclusion about whether or not we're comfortable with a bureaucracy having all powers of government concentrated into one. I, for one, am not. I do not believe that bureaucracy should have courts, and I'm not convinced they should be writing quite as many regulations as they do. So there are ways, for example, the Supreme Court has indulged a lot of the sort of, expansion of bureaucratic power. It looks set to carve it back. Let us hope that they don't kill the patient while they're at it, because at the end of the day, kind of do want clean water if you don't want necessarily, like, I don't know, whatever. Pick whatever agency you hate the most today. But yeah, so I think addressing some of the small state, large state population disparity is important, and fixing the bureaucracy is important, and also cabineting in the president, because here's the problem with a monarch: you just take them as they come, right? And so it's actually, if you look at a list of the prerogatives, the presidency I think is the most crucial problem. Again, this is not a direct critique of Trump. This is a critique of all of our presidents, stretching back, really to Truman. FDR actually, he made an effort with Congress. But if you look at the list of presidential prerogatives that exist today, and you compare them with the official list of the monarch's prerogatives in 1775, George III, what his powers were, and the president today, the difference is that George III had legal title to all the swans in England. That, I don't think, is why our forefathers fought the revolution. It wasn't about swans. It was about constraining executive power. So I'd like to see the wall built out feather by feather.
Do you see any legislative or judicial challenge to the omnipotent executive order?
Well, I mean, legislative, I think it depends on whatever the political configuration is of the day. Here's a point that I made in the book that I've seen made nowhere, and I think I know why, because it traditionally should come from the legal academy, but the legal academy has an odd relationship with the judiciary. It needs its students to get fancy clerkships. A majority of the Supreme Court, which of course the justices are appointed by the president and confirmed by the Senate, a majority of today's Supreme Court, both Democrats and Republicans, have argued for expansion of executive powers while attorneys for the executive branch. Kagan, Breyer, Gorsuch, Kavanaugh, Roberts, and so on down the line. And so if the fastest route to becoming a justice on the Supreme Court, which is still pretty fancy, if the fastest route to that position, the highest and most sort of elusive prize in the legal universe, is to be a toady to executive power, then no, I don't see the judiciary as a check. I see it as an enabler. And that, if you look at the pattern and practice of the Supreme Court over the past 30 years, has been exactly what's happened.
In the past 50 years, I think the number of folks in the press corps has gone down, and the number of people in basically the representation of organizational interest has skyrocketed. So essentially lobbyists. I won't call that corporate lobbyist, call that lobbyist for all manner of things. It seems overwhelming, and it seems, in fact, that the system you just described is best suited for that. They lobby the executive branch, all the departments for regulations. They clearly lobby. Sometimes they seem to write the laws for the legislative branch. And I actually spent 5 years as a volunteer lobbyist in Frankfurt, and it stunned me the degree to which basically I, as a volunteer, seemed like a lunatic, whereas everybody who got paid to do this, and many who got paid to do it at will for whatever side they did it, that's who was respected in the system. So I'm kind of curious to know your thoughts about how we'll ever overcome that at this point to change any of these things.
Sure, that all resonates with me, and you know that probably is the subject of a fourth and even more wrist-slitting book, which is why is it that sincerity is shameful these days, right? And irony and cupidity are not. But with respect to lobbying, you are correct. You know, sort of the reduction in the institutional capacities of Congress does lead to outsourcing. So, you know, the first people to identify the problems with a brewing trade war was the Can Manufacturers Institute, which wrote a letter about a Section 232 abuse of potential sheet metal import duties, right? And so these lobbyists, they're on it, right? There's like a vinyl lobby. There's like, well, you know, there's vinyl wall coverings. So there's a lobbyist for everything. And in some cases, they actually do know better. In some cases, they do write the laws, not necessarily in our favor. But empirically, where it seems the lobbyists are most powerful, and I think probably if you look at corporate America over the past 25, 30 years, this will intuitively snap into place, is that lobbyists are most effective at essentially a for-profit filibuster. So what they do is if there's a law that tends to benefit your industry, vinyl, or certain, like jet planes or whatever it is, or making this, that, and the other. They're very good at preserving the sort of benefits that have already been legislated on their behalf, and they're able to sort of keep those in place. So they're very good at stopping things. They're a little bit less good at actually affirmatively getting stuff in, although they do from time to time.
So I wanted to ask if you'd speak a little bit more about the historical origins of this legal system as it is. Especially the executive power and the mega bureaucracy. But also, what I'm more curious about is if you think that there's ever been a historical era in which there was any American legal clarity or consensus at all.
Well, yeah, so that's a difficult one. So no, I don't think in the absolute there's been any sort of clarity or consensus, like in the grand, like 80% of people were like, yeah, this seems good to us, right? Like there were people who were ambivalent about the revolution, and they're Canadians now. But the, I'm sorry, what was the first part of your question? Remind me. Oh, that history. Where did all this come from? Okay, so let me be clear. There is no American tradition that allows for this concentration of executive power. It is completely antithetical to who we are as a people. There's a reason why we are not British, okay? And there's a reason why we do not have an aristocracy, and there is a reason why we have separated powers. There's a reason why we have a written constitution, and England does not, which is really working out well right now. So there are reasons for all of that, But we can't, at the same time, we can't deny, and the judiciary, our priestly caste is responsible for a lot of this. We can't deny our inheritance from Britain, both good and bad, and the judiciary is a necrophiliac. And if there is something old and dead and English, and it's like PBS, it will be a 9-part series. There are things like sovereign immunity. Sovereign immunity, rex non potest peccare. The king can do no wrong. That's the actual Latin term for sovereign immunity, which, by the way, is a doctrine of American law, and its offshoot is qualified immunity, which says you can basically beat a person to death if you're a cop. And and those aren't my words, by the way. That's Sonia Sotomayor, so this isn't just crazy author. But the doctrine of sovereign immunity had no place in American law, and it's pretty clear why it didn't. It was revived by the Supreme Court about 100 years ago. That doctrine dates to 1292 and Edward I, who, by the way, also invented the case method for law school education. So there are things that maybe we should just leave in grandma's attic. But unfortunately, we have, and the judiciary is pretty bad about it. It keeps bringing these things back. And it's not just originalism. And I think originalism is just not necessarily the best idea. It's also not the stupidest judicial idea, but it's not the best. But we keep bringing back the old. The law loves old stuff. And it loves old stuff simply because it's old. But that's not what this country is about. That's not what our legal system is about. The legal system is about serving everyone well and equally, appropriate to their position in society. And if you're a citizen, that position is always equal.
I wanted to make a comment about jury duty and why we're not having jury trials.
Sure.
It costs a lot of money. If you're going to have a murder trial in a rural county that doesn't have much of a tax base, you can almost bankrupt the poor little county with a serious murder trial. I'm on jury duty for the next 5 months, and case after case after case is being canceled. You just call in, cancel. The next 2 weeks, canceled. The next 2 weeks, canceled. It costs money to run the trials. So that's why the plea deal that she said, why are we doing these plea deals, is because it's less expensive than the jury trials. I'm not for or against, but I know that that's the reason why we're doing plea deals instead of jury trials. Another comment I wanted to make is the comment about jury of your peers. In Lincoln's day, if someone sold you a mule and the mule was blind, everybody can understand you've been cheated. You've been sold a blind mule. But if a bridge has fallen down and the engineer is being sued because he's misdirected or completed this bridge, doesn't a jury of his peers mean engineers, not people with a high school education? Isn't the world too complex for just high school people to make a decision about an engineering project? Those are two of my comments.
Yes. So I'm going to answer the second question first. And I'm sorry, one, that you're on jury service indefinitely. But insofar as, at least, in most states, jury service is quite rare. I would go out and buy a lottery ticket as well, because karma owes you some luck in the other direction on improbable events. Now, with respect to jury of your peers, if I were charged with a white-collar crime, obviously, I would love other white-collar people on the jury. But every American, every adult American of sound mind is a peer under the law. And with the aid of expert witnesses, with the aid of a competent judge, with the aid of professional advocates, any American in a group of 12, as a majority, is fit to opine on the guilt or innocence of another person. And that's just the way it is. Now, with respect to plea bargaining, this is bad for everyone. It's bad for you because people are coming, they're going, they're going to bother you. They're definitely going to drag you down. They're going to go through the whole circus of, well, we're going to have a jury trial. Of course we're confident that we can take this and anyone would acquit or convict, right? But of course you're going to be discharged, because all these things are going to be settled. They're going to be pled out. 97% of all cases are pled out. And this represents a failure. And it's one of American law's paradoxical failures. On the one hand, it's a failure of excessive state power, right? And so with all these zillions of criminal statutes, it's really not hard to throw the book at someone and to say, like, listen, I caught you, it was a DUI, but it turns out, you had your hunting rifle in the back seat, so like 19 consecutive life sentences, end of story. And what are you going to do? What are you going to do? You know, the median hourly rate in the United States is $350 an hour. The bottom 20% of Americans, who tend to be the people who get arrested, can afford 0 minutes of legal representation, none. And so you're just going to plead out. And remember, again, at the federal level, when they bring the case, it's the United States versus you, right? This is not an equal contest. So, but the other weird thing about plea bargains is it also reflects a weird insecurity on the part of the prosecutors, because starting in the 1960s, when the Supreme Court began enacting all these sort of procedural protections that were designed to be sort of pro-defendant and to help mitigate police abuses, and these were all worthy and just, but again, so you had to understand how the system was going to work, and unanticipated consequences. The system is not great at anticipating the consequences of its actions. The problem was it became very easy to make technical mistakes as a prosecutor, and it became very important as a prosecutor to have a very high conviction rate. And so rather than be embarrassed by taking something all the way to trial where you could make a mistake under these arcane and incredibly complicated procedural rules, prosecutors would just plead people out, even if they should have taken the case to trial, even if sometimes, not always, but sometimes, even if sometimes they had to accept less prison time, because that way they wouldn't have to do something that was difficult, that could be overturned, that would be politically unpopular. And so there are all these strange unintended effects. So somehow a system that was designed, at the Supreme Court level on these procedural rules, that was designed to be more pro-defendant actually ended up being anti-defendant. But this is one of the problems with the system that, doesn't really understand itself. And it's a shame. And I'm sorry, by the way, again, that you've had to endure this. The only other recipe, again, is to be elected to Congress. You will be exempt from jury duty. It's the law.
First off, thank you for informing me and opening my eye on several issues. Appreciate that. And second, a statement and a question. I honestly think we're all smart enough to legislate ourselves and govern ourselves, but the problem is being informed and knowing all the issues. And I got 5 examples I could give, but for clarity, just like your one about all the candidates talking about I have never heard that before, and that is such an eye-opener. So who is going to inform us? In other words, I think we can't educate ourselves as much anymore because the country's so big and there's so many people. I don't know. To me, it's like, where's the press? Why does the press just tell us about who's the candidates are wearing and what they're doing? We need to be informed, and I don't know if it's not the press, who else is going to do it? Because I honestly think we're smart enough if we know the facts and if we know enough what to look at. So who could do that?
Talk to Gannett.
It's challenging. I agree with you. I think the fundamental sort of listen, we made a gamble as a society, not even we, people, 250 years ago, roughly, they made a gamble as a society that they were and their children would be and their great-great-grandchildren and whoever came over and was nice enough to raise their right hand and be a decent person and say, yes, I will uphold and defend the Constitution of the United States, would be competent enough to govern themselves. And that is the bet that we've made, and we should not back away from it. Now, at the same time, and this gets beyond the scope of the book, but yes, there are problems with the media. There are problems with the candidates. There are problems that, unfortunately, I probably have created in my prior work in Silicon Valley, and I'm not going to name any names on that. But if you do some digging, we still have a good and free press. And yes, it can be trivial from time to time. And yes, the issues are complicated. But I think that there is, at the end of the day, sort of a basic decency and a work ethic in this country. And if people get out and vote, and they vote for a candidate who they think displays those same characteristics, who doesn't promise them the easy way out, right? Because there are no easy way outs at this point, none. Then I think we'll do okay, or at least we'll have a shot at doing okay. And that's all you're ever going to get in life is a shot at doing okay. And I hope that works out to be the case. I'd like to also point out, and this is something that I would look for in a candidate, and I haven't seen it in a candidate to date. And although I am not a fan of sort of freestyling off the Constitution, I do believe that hidden within the Constitution there is a sacred and important right as citizens. We have the right to be bored by our government. We do. Every day, the news should be a pothole was filled and nothing else happened. The national debt came down a little bit. Slightly more people were slightly better educated. Great. We do have that right. Not every day is an entertainment. Our government is a utility. It is an insurance company with an army. The army is supposed to be deployed over there. Not for very long, only when Congress says so, and hopefully for a good reason. Everything else should be boring and should be here to serve us. And I believe, and unfortunately I can't point to any words in the Constitution, this is our God-given constitutional right as Americans to be bored stiff by our government. So find a candidate like that and vote for him or her once per election.
Let me ask, do you have any solutions for the administrative, quote, administrative or bureaucratic government?
Sure. The first is we need to take away the courts, and we need to do that right now. These sorts of kangaroo. Okay, so let me give you an example. All right, we all love here's my little BuzzFeed story, but it's true, and it doesn't come with a visual aid. So administrative courts, bureaucratic courts, are run by people called administrative law judges, ALJs. And one of them in Maryland, one day, as people do, we all do it, he went to a dry cleaner, and he dropped off a pair of pants. And they lost the pair of pants. And so, being a man steeped in the American law, he sued the dry cleaner for $67 million. And it took a lot longer to resolve than you would think. The dry cleaner was bankrupted. Now, it turns out that the bureaucracy that employed him thought that he did not display adequate judicial temperament. So, of course, you know what his response was. He sued them. Which, again, took a little bit longer to resolve than you might think. But, so these are the kinds of people who are running the bureaucratic courts. Not all of them, some of them. I'd say we can let them go. I think we should remove the courts basically immediately. ALJs do not cost much less than full Article 3 judges, real federal judges, okay? It's another 20 grand a year. It really wouldn't be that much. The judiciary, entire judiciary itself, right, federal judiciary itself, costs 55% as much as the Gerald R. Ford aircraft carrier presently. And that's a bargain. That's a bargain. In the arsenal of democracy, I'm for aircraft carriers. I'm also for a robust and appropriate federal judiciary that is properly appointed and independent from the executive. And if we need to spend an extra $1 billion on that, even I, as a budget disciplinarian, am okay with it. Now, as for removing sort of the legislative powers, that is going to take some time. Congress is simply not competent to legislate on everything right now. We do not want Congress setting the safety standards for nuclear reactors by itself. And perhaps it never should. But we do need to have a serious discussion as a people as to whether or not we want all three branches of government rolled up into one. I think the answer is probably no. Thank you very much.